Welcome, everyone, to this Interstate Compacts 101 session hosted by the Council of State Governments National Center for Interstate Compacts. My name is Andrew Bates, and I will be your host for today's proceedings. I'm a staffer here at CSG, where I work mainly on interstate compacts. A bit about the Council of State Governments. We are a membership organization for states. Every state is a member, and every state pays dues. We provide technical assistance and research on best practices and innovative policy solutions to a wide variety of state and federal agencies. Through the CSG National Center for Interstate Compacts, we support states and professions in the development and enactment of interstate compacts to address license portability challenges. We're thrilled to have you with us today to learn more about these powerful documents that allow states to address policy issues that uniquely concern the states. To introduce us to the history and theory of interstate compacts, I'm happy to be joined by Jeff Litwack, who serves as legal counsel here at CSG as well as the Columbia River Gorge Commission. Jeff, I'll let you introduce yourself more thoroughly here in a second, but first I do want to say thank you for being here and for providing your expertise. The floor is yours.
Thank you, Andrew, and I'll offer my welcome as well. As Andrew introduced me, I'm Jeff Litwack. I'm the in-house counsel for the Columbia River Gorge Commission, which is an interstate compact agency created by Oregon and Washington. I've been the Commission's counsel since 1999. And in addition, I teach an interstate compact law class at Lewis and Clark Law School. I've written a textbook on compact law now in its 4th edition to support that class. I also write an annual update on judicial, legislative, and administrative developments in compact law, and I've done that for a couple of ABA, American Bar Association presentations since 2008. And then I'm also a co-author on the 2nd edition of the ABA's book on the evolving law and use of interstate compacts. And at the end of this program, Andrew has a discount code for that ABA book. I like to think of this program as an introduction to the rich political and legal context of compacts. I'm going to give a primer on what compacts are, what they do, how they fit into our federal system of government, and a little bit of history of compacts. So let's take a look at what is an interstate compact. Andrew, slide, please. So no court has given us a concise definition of a compact. I like to think of a compact as a legislatively enacted agreement between states in their sovereign capacity as states. It's kind of a dense definition, but when you break it down, it's pretty straightforward. States act in their sovereign capacity when they legislate, and interstate compacts are enacted as legislation. They go through bicameralism and they get a governor's signature. They're also contracts. That means that they bind the states to the terms of the compact. We know that they're contracts because the Supreme Court told us so in its first compact case in 1823. It said a compact is a contract. Now, compacts exist as a means by which the states can speak with one voice. They do so to address their regional problems, they resolve disputes, and they respond to national priorities that the national government is not responding to. Despite what you might have heard in your high school civics class, supra-state problems, that is, problems that cross state lines, do not necessarily require a federal solution. Now, we often hear people ask why their state should enact a compact, because doing so gives up some of that state's sovereignty. I disagree with that concept. Compacts are voluntary arrangements between states. They differ from a traditional vertical and preemptive relationship between the states and the federal government. As a voluntary arrangement, a compact is really a classic expression of the states preserving their sovereignty, because with a compact, it's the states that choose how to govern themselves. Even in some cases, the Supreme Court has framed claims of sovereignty in compact cases as the states choosing to share their sovereignty, sharing their sovereignty. That concept of shared sovereignty, that's the key to a compact. It's not a loss of sovereignty, but sharing of sovereignty is what makes each state richer for enacting the compact. And compacts are effective. We have more than 250 current compacts. It's the best testimony that compacts are effective. States that engage with their sister states reap large rewards of self-governance when they resolve their own regional and even national problems. All right, Andrew, next slide, please. This is also a good testament that compacts are effective. This is a partial list of the policy areas and interstate problems that states address through compacts. There's more than 30 policy areas listed on this slide. Compacts create statutory and in some cases administrative structures that can address almost any policy issue that crosses state borders. Andrew? Now, most recently, states have been enacting professional licensure compacts at a phenomenal pace. 10 compacts in the past few years and more in development. And Andrew's going to talk more about these in the second half of this program, but I just wanted to highlight this because this is a growing area for interstate compacts. Andrew, next slide, please. Let's talk about why states join compacts. Most often, the states want some type of unified approach to a shared problem, policy issue, a dispute to resolve. Up until the late 19-teens, about 1918, all compacts were in some way related to solving a border dispute. Now, most of those border disputes also involved some other policy area, such as criminal jurisdiction or fishing rights. But corresponding to our society becoming more mobile, state borders became blurred in so many ways that the states actually needed to start working together. You know, I think of state borders where I live as little more than a welcome sign on a bridge or an interstate highway. We know states have vastly different policy priorities, but they also agree on many of them. And it's in those areas of agreement that states have always wanted, and they still want, to resolve those problems locally by themselves. They want to do so rather than wait for the federal government and rely on a federal solution that may not reflect their own priorities. And again, compacts work. More than 250 current compacts, more than 30 policy areas. That's pretty good evidence that compacts work. Every state is a party to 25, 30, or in some cases, more than 40 compacts. We know compacts work. Andrew? There's also some scholarship that gives some interesting statistical correlations for why states join compacts. Professors Bowman and Woods, they studied compacts that are open to membership in all the states. We're not talking about bi-state compacts or regional compacts. These are compacts where all the 50 states, territories, the District of Columbia can join that compact. And they reached many conclusions. A couple of their correlations really stand out to me, such as states with a weaker fiscal or institutional capacity will use compacts to fill that gap. And that states that are adjacent to states that have already joined a lot of compacts will tend to join more compacts themselves. If you're interested in the article, I gave a site at the bottom of this slide. I think it's a very interesting article and I do recommend it. Andrew? All right, no discussion of compacts would be complete without some discussion of the compact clause in the US Constitution. So we have to look at the Constitution. It's a pretty straightforward clause. It says no state shall, without the consent of Congress, enter into any agreement or compact with another state or with a foreign power. So let's park that foreign power phrase for a moment. I'll get to that at the end of my part of this program. But I want to talk about a few of the broad interpretive issues that have come up with this compact clause over the decades, the more than 100, almost 200 years now of litigation involving compacts. First, courts have had to decide what constitutes consent. Turns out it's a pretty easy standard. It requires some positive act of Congress, but it also may be implied. Consent can be implied, such as when Congress acknowledges a compact in some other congressional act. Another issue is that a few cases have had to consider the timing of consent, whether consent is needed before the states enact the compact or consent is needed only after the states enact the compact. Universally, the courts have concluded that consent may come at any point in time. A third thing that's come up, and this is more historical, although there's been one very recent case in the last few years, is what the terms agreement and compact mean. There's another provision in Article 1, Section 10, Clause 1, so the same section, but a different clause of the Constitution. And that prohibits states from entering into treaties, alliances, and confederations. In the past, the Supreme Court had struggled a bit with distinguishing between compacts, agreements, treaties, alliances, and confederations. It's really not much of an issue now, but it's something that the courts have had to struggle with a little bit in the past. And then finally, an issue that comes up pretty frequently is when is congressional consent needed? Not a timing issue, but when is it that Congress must give its consent to a compact or need not give its consent to a compact? And that's an issue because, again, if you look at the phrase of the compact clause, it uses this term, any agreement or consent, or any agreement or compact requires consent. The word any would suggest that all compacts need consent. Andrew, next slide, please. So despite that seemingly absolute requirement for consent to all compacts, the Supreme Court has told us that not all compacts require consent. The court has given us two situations where consent is required. These are pretty broad situations, but two situations. First, a compact needs consent when it would in some way affect the supremacy of the federal government. The other is when the compacting states would in some way create a disadvantage to the non-compacting states. So what we're really looking at here is some impact, some impairment of the federalist structure of the United States, either vertically between the federal government and the states, or horizontally between the states themselves. The last time I checked, which is about, well, it was several years ago, about 40% of the compacts don't have consent and apparently don't need it. Now that number is probably a little bit off because the new licensure compacts do not require consent. But I think if you use 40% as a rough estimate, that's a pretty good estimate. To really understand how this apparent requirement for consent for any compact became only a requirement for consent for some compacts, we've got to dive into history a bit here. Andrew, let's look at history. All right, compacts have been around since the very earliest of colonial times. We know there was a Hartford Treaty in 1650. That may be the oldest compact, if not the oldest, and certainly one of the oldest. So we're talking a long time now. In colonial times, these agreements between the colonies were supposed to be approved by the King's Privy Council back in England. The Judicial Committee of the King's Privy Council, it was one of the high courts in England during the colonial times, and one of its roles was to hear appeals and resolve disputes in England's colonies. The Privy Council wrote decisions, just like our courts do today. They have a lot less reasoning, they're much shorter, but you can actually see images of these Privy Council original registers. And the image I'm showing you on the slide here is the Privy Council's entry approving the agreed boundary between Connecticut and the Rhode Island Providence plantations in 1727. So you can actually read these original decisions from the Privy Council. Andrew? So the colonies were used to that requirement of seeking approval for their agreements, and thus they stuck that requirement into the Articles of Confederation. Here's Article 6 from the Articles of Confederation. You see a compact clause that looks very similar to the US Constitution compact clause. So we had a compact clause in the Articles of Confederation, which then the states transferred over to the US Constitution with slightly different language. But here's the key. In practice, the colonies did not submit all of their intercolonial agreements to the Privy Council for approval, and they did not submit all of their interstate agreements after they became states to the Confederation Congress. There were many agreements that the colonies concluded only through their colonial councils, and then later the states concluded only through their state legislatures. And that practice of not sending agreements to the Privy Council or to the Confederation Congress, that helped inform the Supreme Court's decisions that the compact clause does not require consent for all compacts. That practice appears in some of the early writings in colonial times, and the courts referred to those writings, and actually the courts referred to this practice in some of their decisions. So I like to tell folks that if you're working with a compact that doesn't have and doesn't need consent, you really need to direct your appreciation to those early Americans who flouted the jurisdiction of the Privy Council and the Confederation Congress, because had they actually sought approval for all compacts, our test for whether consent would be needed for all compacts might look very different today. All right, Andrew. Another interesting bit of compact history is that the negotiation of the Virginia-Maryland Compact of 1785 played a pretty significant role in the transition from the Articles of Confederation to the new US Constitution. 1785 was the time when we were operating under the Articles of Confederation. That Virginia-Maryland Compact was a boundary compact. It established the border between the states along the Potomac River, but it also addressed the free and open use of the Potomac River. And that was necessary because, as you recall from your history classes, the Articles of Confederation created only a weak federal government. The federal government under the Articles of Confederation had no authority to control interstate commerce. So if the states wanted a free and open Potomac River, they themselves had to create the laws to prohibit interference with that open use of the Potomac River. Interestingly, George Washington hosted the state's delegates at his home at Mount Vernon. Sounds very nice, very altruistic of him, but you got to remember he was also an industrialist, so he probably had a vested interest in a free and open Potomac River. You can imagine that during that negotiation over the Potomac River, the delegates probably realized that every interstate river in the new country would need one or more compacts to manage their use. And so you can imagine the delegates thinking, gosh, we're gonna have to do this type of negotiation for every river. We have got a better solution, and that is let's create a federal government that has more authority than the one under the Confederation, the Articles of Confederation. So those delegates envisioned what became the Annapolis Convention, which then led to the Philadelphia Convention and ultimately to our new Constitution. Andrew? Andrew and I wouldn't be able to tell you that compacts are a proven and effective solution today without a long history of the Supreme Court and other courts consistently supporting the state's uses of compacts. Many of those legal principles in the early court decisions are still principles today. We've got this important case, Green v. Biddle. It's the very first case from the US Supreme Court, really from any court, addressing interstate compacts. And in that case, the Supreme Court told us that the states have a sovereign capacity to enact a compact. They also told us that compacts may be implied and that a state may not enact a new law that violates a compact. So we have this sovereign capacity, we have this answer to how do we get consent, and we have a question about the binding nature of compacts, all coming from the very first case that the US Supreme Court decided. We've got a case called Hinderleiter. In that case, the Supreme Court affirmed the supremacy of a compact where there was an apparent conflict with the state constitution, not just a state law, but a state constitution. We have a case called Dyer v. Sims. In that case, the Supreme Court essentially reaffirmed its decision in Hinderleiter. It didn't mention Hinderleiter, but it reaffirmed that states may not avoid their compact obligations by simply claiming that the compact would avoid their state constitution. And also importantly, in that case, the Supreme Court said that a delegation to a compact agency is an ordinary delegation, just like a state legislature would delegate to a state administrative agency. We've got this case, Virginia v. Tennessee. In that case, the court confirmed a number of earlier cases about the scope of the compact clause. That is, when does Congress need to grant consent to a compact? And then we have Kyler v. Adams, the most recent of these compact cases on my list here. And that established that when a compact receives congressional consent, and when it's of a subject matter that's appropriate for federal legislation, that compact itself becomes federal law on par with congressionally enacted federal statutes. So through a compact, the states can enact federal law themselves. And then finally, we have New York v. Wilcox, which was a New York state decision state court decision, low-level trial court decision, which affirmed the creation of the Port of New York Authority, now known as the Port Authority of New York and New Jersey, which was the very first compact agency. But that case turned out differently. Whether we'd all be looking at compact agencies today or not. Andrew? So we talked a little bit about compacts, but I want to just emphasize that a compact is not the only way that states cooperate and resolve disputes. Here are some of the more popular ways that states cooperate. And really, states use many of these ways more often than compacts. Just like any policy problem, the states have to consider the best fit for the problem. And a formal compact is not always the best fit. I thought I'd take a couple of slides here and compare compacts to a couple of these other forms of cooperation. Andrew, can we move on? Let's start with a compact versus a non-compact agreement. A non-compact agreement is one, it's what I think of as an administrative agreement. It tends to be an agreement between state agencies or state officials. And it's not enacted by the legislature. Remember, compacts are enacted as legislation. These administrative agreements are not enacted as legislation. They're simply agreements between officials and or between agencies themselves. With a compact, no state agency, no agency can act inconsistent with that compact. But with a non-compact agreement, an agency that is not a party to that agreement might not be bound by that agreement. So we have a significant difference there between a compact and a non-compact agreement. In the past, we've seen distinctions between governmental functions and proprietary functions, with governmental functions such as licensing and regulation requiring a compact. So if the states want to create a bi-state or a multi-state licensing or regulatory system, that might require a compact. But if the state's entering into an agreement, such as cooperative purchasing, that would not require a compact. You don't see this distinction much anymore, but you see it enough that it's worth mentioning. And then finally, there's a difference in where the authority comes for states and state agencies to enact compacts versus non-compact agreements. Remember, the authority for states to enact a compact, that's inherent in the state's sovereignty. But to enact a non-compact agreement, the states have provided statutory provisions in their state constitutions and their statutes. Those authorize non-compact administrative agreements. And what's key here is that those constitutional and statutory provisions differ from state to state. One of the big differences is that some states only allow an agreement, an administrative agreement, where all of the entities to that agreement would have the same power to undertake tasks specified in that agreement independently. So if they all have the authority to do one thing, that they could enter into an agreement to collectively do that one thing. But other states allow an agreement where only one of the contracting parties has that power. So the effect there is to expand the power of the contracting parties to share the authority from one of the parties when the other parties may not have that authority independently. Sometimes states create critters that courts confuse with interstate compacts. A decade ago, maybe 15 years ago, there were a number of law review articles or a few cases that were questioning whether the Regional Greenhouse Gas Initiative, which is a cap and trade program for large power plants in the Northeast, whether that's a compact that requires consent. There were also similar cases involving Easy Pass. So if you use Easy Pass in one of the 18 or 20 states that uses it for toll bridges and toll roads, there are some questions whether that was a compact between the states. There is a couple of cases that disagreed on whether the Smarter Balance Assessment Consortium was a compact. In that case, you've got a number of states enacting parallel agreements with the University of California. Not all the states entering into an agreement with each other, but they're each entering into an agreement independently with the University of California, and whether that would require a compact. Excuse me, whether that created a compact. And again, there's a couple of cases where one court said yes and another court said no. Courts have, again, decided both ways whether the Unified Commercial Registration Plan is a compact. That's a program that collects and allocates interstate truck registration fees. Some courts have said that is a compact. I question that. Interestingly, it's the U.S. Secretary of Transportation that appoints all the members to that plan board, not the states themselves. So I wonder, is that really a characteristic of a compact? And then, somewhat humorously, there was a case several years ago where a plaintiff had argued that the Federation of State Massage Therapy Boards constituted a compact. The court pretty quickly said no. And I believe in the last few years, there was another case involving another similar federation of the state boards where the court had to conclude that it was also not a compact. Andrew? All right, let's look at compacts and uniform laws. Probably know what a uniform law is, but quickly, a uniform law is like a model law. The purpose of a uniform law is to create some amount of uniform treatment between the state's laws in a particular policy area. Like I said, it's a type of model law. The Uniform Law Commission and a number of other entities draft these uniform laws and then put them out into the ether for the states to consider. The states do not have to enact uniform laws, and then despite their name uniform, the states actually don't have to enact the same model text. So very often, when the states adjust the text of their uniform laws that they do enact, those uniform laws are distinctly non-uniform. This differs from compacts because the contractual nature of a compact requires the states to enact substantively the same legislation. So if the states need a high level of uniformity, a compact might be a better tool than a uniform law. However, amending a compact requires all the party states to do so. And where you've got 50 state compact or even a 2-state compact, that can be difficult to get the states working together once they've been working together for a while to amend their compact. But with a uniform law, each state enacts that uniform law independent of the other states. And because there's no requirement for that substantive sameness, states can amend or repeal uniform laws just like they would any other state legislation. So it's much easier than a compact. Again, states really need to evaluate their needs and then ensure that a compact is the right tool for the job. As we've said a few times now, when it's the right tool for the job, it's an effective tool. Andrew? And finally, we're going to unpark binational compacts. This comes from the compact clause, where there's a need for consent for agreements between a state and a foreign power. There are several compacts that involve Canadian provinces. We have a couple of Great Lakes compacts that have the provinces participate, but they do so through a supplemental agreement or a companion agreement. We also have some emergency management assistance compacts, 3 of those, and then 4 compacts that are specific to forest fire response. Those latter compacts, the emergency management assistance compacts and the forest fire compacts, those all have congressional consent. And in that congressional consent, the states and the provinces are listed as direct members of the compact. With the Great Lakes compacts, those also have consent, but there's some confusion and sometimes question about what the supplemental agreement that brings the Canadian provinces into that compact, what those actually are, and whether those are binding. This is not a complete list of all the state-foreign compacts, like domestic compacts. States and provinces have created arrangements that look like compacts, but they don't refer to themselves as compacts. Because I'm in the Pacific Northwest here, One of the examples that I like to give is the Pacific Northwest Economic Region, which is a number of the Pacific Northwest states and a number of Canadian provinces working together on economic policy. Is that, or is that not a compact? There are also hundreds of agreements between a single state and a foreign government. I've listed here a few of the significant policy areas where you have those agreements. What's really interesting about this is that there's been some scholarship in the past several years about congressional consent for these state foreign power agreements. One of the interesting findings in that scholarship is that the states actually submit very few of their state foreign agreements to Congress for consent, and Congress doesn't demand to review those agreements. So we don't have a lot of examples of consent to these state foreign power agreements. In the few examples that we have and in the scholarship, there seems to be some agreement that the courts are going to apply the same tests for consent that they would for a domestic compact, the ones that we talked about a few minutes ago. The Supreme Court hasn't yet decided this, but this seems to be the consensus among the scholars and the courts that have, the few courts that have addressed it. So compact jurisprudence, compact clause jurisprudence actually works for other types of agreements. There are also cases where courts have applied compact law principles to agreements between states and tribal governments and to interlocal agreements, agreements between local governments themselves. Any Andrew? And in my last slide here, I thought I would just point out that there are licensure recognition in the some of the international compacts. Thought I'd just point this out because of the focus on licensure compacts. This is one of the 3 international emergency management compacts that I mentioned on the last slide. So I'm just going to conclude by saying, compacts, they can address a wide range of policy problems where they're the right fit for the problem. They're really effective. We have more than 350 years of colonial and state experience. We've got judicial support. We've got over 250 compacts, and that provides a really good base for today's law and use of interstate compacts. And with that, Andrew, tell us about licensure compacts.
All right, thank you so much, Jeff, for that excellent introduction to the history and theory of interstate compacts. And so now we get to focus on a particular type of interstate compact that concerns occupational licensure. So the CSG National Center for Interstate Compacts, who's my employer, was founded back in 2004 in response to the growing importance of interstate compacts. The original Nurse Licensure Compact was created around the turn of the millennium, so CSG recognized the importance of educating states about these documents. Here at NCIC, we concern ourselves with all kinds of compacts, but where we have seen the most growth in recent years is in the area of occupational licensure interstate compacts, which seek to remove barriers to practitioners practicing their licensed professions across state lines, and thereby expanding public access to services and increasing mobility for licensed professionals. Sorry, and so to start us off, I do want to zoom in on a few of the key benefits of interstate compacts as they relate to occupational licensure. So one is what we refer to as economies of scale. And what that means is that a collective solution to many policy issues is more streamlined and efficient than a piecemeal approach. In occupational licensing, we often see states enter into individual two-way reciprocity agreements with one another. But in recent years, we've also seen many states enact unilateral, what are referred to as universal license recognition laws. And sometimes these are called universal endorsement or universal reciprocity. These reciprocity agreements and universal recognition laws certainly lower barriers for some practitioners, but they do so with a piecemeal state-by-state approach that still frequently involves significant effort on both the part of the practitioner and on the part of the state licensure board. Interstate licensure compacts centralize and streamline interstate practice for particular professions, reducing the hours for licensure boards that they have to spend processing interstate applications, and for practitioners, reducing headaches and costs associated with obtaining and renewing multiple state licenses. Second, we have flexibility and autonomy. So federal policy cannot always take into consideration all of the nuances that we see with individual states, or account for how states might accommodate a particular policy issue. Compacts create a forum for states via their delegates to what we call the Compact Commission to negotiate and come to a workable agreement on these issues that does account for their differences and unique features, such as for occupational licensing, each state's unique scope of practice for a given profession. You have dispute resolution. So that forum provided by compacts also allows states to resolve any conflicts that may arise without needing to pursue costly and contentious litigation. And state and federal partnership. So as I mentioned, on issues concerning both the federal government and the states, compacts allow the states to pursue a workable solution without need for direct federal intervention. Occupational licensing reform has been a key aspect of the Biden and Trump administration's labor and workforce agendas. So this is definitely something that's on the radar of the federal government. The Department of Defense is actually especially interested in licensing reform for the benefits that it has for military spouses who have to move so frequently. But rather than pursuing a federal mandate, DoD is partnering with the Council of State Governments to help states and professions develop additional licensure compacts for several professions, including dentistry, social work, massage, cosmetology, and K-12 teaching. Some compacts in other policy areas, including the Columbia River Gorge Commission, where our friend Jeff is counsel, even provide for representation of concerned federal agencies on the Interstate Commission that administers the compact. And then you have cooperative behaviors. So compacts build on a long tradition, as Jeff mentioned, of cooperation and trust among the states. So a past example of this is driver's licensing. The fact that you can use your state driver's license in other states, that actually originated with the states through an interstate compact. States agreed to recognize one another's driver's license on the principle that each state is doing its own due diligence in screening applicants. And as a result, states maintain control over driver's licensing, that's a win, without harming their residents' ability to utilize our interstate highways, which is another win. Occupational licensure compacts rely on much the same principle of shared trust. States agreed upon a minimum set of requirements for states to join the compact and a minimum set of requirements for licensees to access the compact, which accounts for individual state differences. And then states agree to recognize all licenses from all member states that meet these minimum requirements. It's a one-for-one license transfer. So over time, these licensure compacts become a platform for licensing boards and professional associations to come together and really hash out issues in a proactive manner. All of these licensure compacts do have the goal of becoming national in scope, which at CSG we define as 45 or more states. And you really do see these compacts turn into this sort of forum for the advancement of sound licensing policy and to drive uniformity in professions, which benefits everyone at the table. And so here's a few of the basic elements of interstate licensure compacts. So as straightforwardly as possible, under a compact, licensees who are based in a member state are able to practice in other member states using their home state license. However, each member state retains the ability to regulate the profession. So the scope of practice of each state is unchanged. Each state gets to continue to determine, expand, limit its scope of practice as it sees fit. And member states are able to investigate and discipline practitioners using the compact. So just because a practitioner, based in another state is practicing in your state via the compact, that does not impact your state's ability to take that privilege to practice away from that licensee if they're in your state. Background checks are another standard feature of interstate compacts for licensure. We understand that, if we're expanding practice to include, a lot of out-of-state practitioners, it's also very important to maintain public safety. And so background checks ensure that. And member states administer the compact through an interstate commission. There'll be a little bit more on the interstate commission in just a moment, but that commission is composed of member state officials and is tasked with acting on behalf of and is accountable to the member states. So when a profession decides that they want to pursue an interstate compact, they can come to CSG, where we use our proprietary transparent compact development process, which is shown here on this slide. We adhere faithfully to this process. We do not grant any exceptions. We do not give our seal of approval to a project unless it has gone through our thorough development process. And so we start by convening an advisory group, also known as a technical assistance group, composed of about 20 state regulators, state legislators, members of the profession, issue experts, and attorneys. And this group really crafts a set of recommendations for the compact. They don't write the compact itself, but they consider the landscape for regulation and licensure of the profession and put together a set of recommendations for design of the compact. And then the advisory group's recommendations are then transmitted to the drafting team, also known as the document team. And that is a smaller group of state officials, attorneys, and issue experts who actually writes the compact language. So then this draft, once the document team has a draft put together, the draft is circulated for a thorough stakeholder review in which CSG vets the compact with state boards, legislators, professional associations in the states, as well as with the general public. And comments collected during stakeholder review are then compiled for the drafting team, who goes back into their meetings and considers all of the comments and amends the draft where appropriate. And then the revised draft is finally approved by the advisory group, which is the broader project team, and then goes out to the states for enactment. So to join a compact, as Jeff mentioned, the state must legislatively enact the compact into statute. And during enactment, CSG supports states in the profession in question by providing technical assistance and informational testimony to states who are considering the compact. And we also track and review state compact legislation to ensure that all states are enacting substantially the same language. After all, this is a contract, so everyone does have to be signing on to the same language. Once the specified threshold of states to enact the compact is met, and that's normally 7 to 10 states to activate the Interstate Commission, CSG also assists, and this is phase 3, with the setup of the Compact Commission, which is, again, the panel of member state officials tasked with implementing the compact. Setup would include the drafting of initial rules and bylaws relating to the administration of interstate licensure under the compact. So phase 1 typically takes about a year, but it takes as long as it takes. Sometimes it takes more, sometimes it takes less. And if revisions are made after stakeholder review that require another stakeholder review, we will do that. It takes as long as it takes. We don't believe in cutting corners, and these documents are intended to stand for generations. So it's very important to get it right the first time. Phases 2 and 3 are more continuous and definitely overlapping. As the commission is being set up, of course, other member states are still considering joining, but generally any state who joins prior to the initial meeting of the Compact Commission is able to participate in initial rulemaking for the compact. And then here's a bit more about the Interstate Commission. So it is classified as a sub-federal suprastate public entity. It is an extension of each member state government and is thus a governmental entity and not a private organization. So this is not a smoke-filled backroom situation. Meetings are public and rules of the commission are subject to public comment, although rules once adopted are binding upon the member states. The commission is able to establish committees tasked with handling certain issues, including an executive committee responsible for day-to-day matters. And the commission may also hire staff, although we generally see that staffing needs tend to be minimal. In fact, there are over about 5 million nurses in the United States, and the Nurse Licensure Compact has 1 full-time employee. So there's not a ton of legwork on the part of the commission staff, but it is useful to have someone, sort of in charge of the very day-to-day matters of interstate licensure. And the most important thing to remember here is that the commission is an instrumentality of the member states, that it serves the member states and not the other way around, and it acts upon the member states' behalf. It does not answer to any outside organizations, such as professional associations or regulatory associations. However, these sorts of organizations are often granted ex officio seats on the commission, but any ex officio seats for professional or regulatory associations are always strictly non-voting and are intended as an advisory, not a decision-making type of role. And so here's a list which Jeff included earlier of occupational licensure compacts today. These are listed in alphabetical order. And to give you an idea of where each of these are at in their development process, the compacts for APRN Counseling, occupational therapy, and physician associates are still working towards their thresholds for activation. The audiology and speech compact is currently going through commission setup right now. And the EMS, medical, nursing, physical therapy, and psychology compacts are all fully functional and are currently working towards national status. And I would also mention CSG is currently working with the Department of Defense to develop compacts for 5 other professions. And with even more coming down the line. But the ones we're working on right now are cosmetology and barbering, dentistry and dental hygiene, K-12 education, massage therapy, and social work. And so why is it important to expand license portability? And so as you saw on the previous slide, most of the compacts that we have currently are in the healthcare field, generally speaking, whether it's mental health, allied health, physicians, PAs, et cetera. And so one reason that license portability for healthcare professionals is more important now than ever is that society today is more mobile than ever. And that's owing in part to the development of enhanced communication technologies, allowing for remote work, including telehealth services in the healthcare field. The current regulatory landscape for telehealth is a complicated patchwork, to say the least. And so we craft these compacts to create regulatory certainty for telehealth where there is none currently. And we also, as I mentioned, craft these to support military families. Military families move on average every 2 to 3 years. And so for the Department of Defense, it's a very important aspect of, general readiness is to make sure that we're making life as easy as possible for military spouses who have to move so frequently and transfer their license each time. And there's, of course, the aspect of increasing healthcare access, especially in rural areas where telehealth might be more of a big deal, but that also applies to underserved urban areas as well. And to enhance states' ability to protect public health and safety. As I'll get to in a moment, there's a licensure data system that really functions as the engine of the compact. And that ensures that states are communicating on investigations and discipline of practitioners. So if a practitioner runs afoul of the board in one state, they're not able to just jet over to the next state and get a license. That adverse action is going to be reported to all member states and they can take action accordingly. So we often hear from licensure boards that they really appreciate this sort of added regulatory reach that they're granted by a compact. And as I mentioned, enhancing the exchange of licensure information, that's something that is not currently necessarily the case. As I mentioned, it's really difficult for boards to track down practitioners in other states. And so we account for that in these compacts. And we also, of course, have an aging population, as well as, an increasing veteran population owing to, recent history. And so these compacts, allow us to move around practitioners between areas of need to account for, that aging population and that high number of veterans that we have today. And of course, practical advancement for current and future generations. These compacts, as I mentioned, are intended to stand for generations. They're very durable documents and they can only be altered through all states repealing the legislation and enacting new legislation, as Jeff mentioned. So by acting today, we are reducing barriers, not just for practitioners, in the current day, but we're also hoping to provide, borderless practice for practitioners of each profession that has a compact for, centuries into the future. And so here's some specific advantages of licensure compacts. So one of the big ones is uniformity. Licensees are able to practice in another state via their valid license and member state on a one-to-one basis. And there's no need for the licensee to parse whether their training, educational coursework, and experience qualifies them for a license in another state. Basically, if you're licensed in good standing, you're pretty much in as far as the compact is concerned. Further, states are able to act as a unified body on issues relating to interstate licensing. And the compact is substantially the same for all member states. All rules of the commission are binding to the same extent on all member states. and unilateral action is sort of implicitly discouraged. Although I do always want to remind our audience that states remain able to define the scope of practice for profession, as well as to license, investigate, and discipline practitioners. And then the data system, as I mentioned, performs most of the work of verifying a licensee's eligibility for the compact. This data system also ensures that member states are notified when a licensee is disciplined by another member state. So you can't just hop from one member state to another and keep practicing. That is always going to be documented. We recognize that if we are going to open the door to more out-of-state licensees, we must not allow this to jeopardize public protection. And so that's why we include FBI fingerprint background checks, as I mentioned a bit earlier. And as I mentioned, the data system ensures that boards are communicating with one another. We, as I mentioned, often hear from boards, it's quite hard to track down licensees out of state. So the compact centralizes and simplifies this process. And as I mentioned on the slide about the structure of the commission's national office and staff are able to handle day-to-day matters and to coordinate with external stakeholders, including professional organizations, as well as with other licensure compacts on best practices for compacts and changes in the professional licensure landscape. So the compact allows states to be responsive to changes and licensure policy, with a unified voice. And so for the last little bit here, just want to emphasize these three key advantages of licensure compacts, which are one, that state licensure processes remain in place, meaning state sovereignty is preserved. Participation is voluntary for states and licensees, so state sovereignty is preserved. And state practice acts, of course, are not impacted. So state sovereignty is preserved. And on these last couple slides, we have a couple of myths that we would like to debunk. These are frequent concerns that we hear at NCIC from state officials and members of the public. And so one of those is that interstate compacts are a takeover of state policy. In reality, states negotiate the compact policies themselves and actually sometimes use compacts to avoid what we call takeovers. Compacts preserve state regulatory authority and minimize or avert federal intervention. And an example of that is the driver's license model that I mentioned earlier. Another myth is that interstate compacts are owned or controlled by outside organizations. And this is commonly a concern that people have about the Interstate Commission. But in reality, compacts, as we've emphasized and re-emphasized, are governed by the member states themselves. And compacts are an instrument of the states, accountable to the states, and the commission is composed of member state officials. So it is very much, commission is very much an instrument of the states and composed of the states. And finally, compact commission rules and bylaws thwart state sovereignty. This is another common concern about the commission because people see that binding rulemaking piece. But in reality, rules that are written by the commission concern only the implementation of the interstate license portability of the compact. So each member state does, as I've re-emphasized several times, retain the authority to regulate the profession in question, including to determine scope of practice and to investigate and discipline licensees. So those are a few common misconceptions that we see here at NCIC that we just wanted to take a moment to address. And finally, as Jeff has mentioned, we do have a promo code for a discounted copy of the treatise, The Evolving Law and Use of Interstate Compacts, of which Jeff is a co-author. Jeff, do you have anything to add about the contents of your book?
Well, it's a wonderful book. It's pretty complete. This is a book that I like to tell people has been decades in the making. This is the second edition of a book. The first edition was 2006. And I like to think of that book as a continuation of another book that was published by CSG in 1976. That was the second edition of a 1961 book. Prior to that, there was a 1950 book on the use of interstate compacts. So this book here is really a continuation of that, all the material from those prior books. And because the folks involved in drafting this are tied in some way to CSG, and CSG was involved in those early books. This is really a wonderful CSG product, even though it's published by the American Bar Association. So I do recommend it.
Fantastic. Yeah, my first assignment when I joined CSG was to read the introduction of this book, and I was much better for it. Well, thank you for that, Jeff. And finally, on behalf of CSG, I just want to thank everyone for taking part in this presentation. I also want to thank Jeff, of course, for lending us his expertise. Jeff, we truly value your efforts on all fronts. And we've definitely sought to anticipate and answer as many questions as possible. But if you have any questions about this material, please feel free to reach out to Jeff or myself at the addresses on your screen. And with that, I think we can wrap it there. So everyone take care and please be well. And thanks again.
Bye, everybody.